Bismillah ar-Rahman ar-Rahim. We are pleased today to have Professor Muhammad Ghaffer. He's the Director of Patents Unit in the Deanship of Scientific Research, DSR, and he's also a Professor of Chemistry in the Department of Chemistry. Professor Muhammad, he got his bachelor degree in chemistry from King Saud University, his master degree in radiochemistry from the University of Salford in the UK, and his PhD in nuclear chemistry from the University of Kentucky in the USA. The title of this talk is the Introduction to Intellectual Property. Is a very important topic that we should all be aware of, and I'm very thankful for Professor Muhammad for sharing this information with us. Please.
Thank you very much, Dr. Abed. Bismillah ar-Rahman ar-Rahim. I will give a brief introduction about intellectual property, its increasing importance in the university atmosphere, and shift from funding, the classical funding of projects from the classical research into IP producing projects. So we remember this saying. It's an old saying in academia, publish or perish, but now a lot of people converting to this one. So patent and prosper, because maybe 1% of the time, or 0.5% of the time, you get lucky and you will produce a lot of money. But in the old way, you always stuck with in your salary only. So universities now are interested in producing intellectual property that is capable of generating revenue for the university and staff. So it's a contrast between authorship of papers and inventorship of inventions and intellectual property. So this new term, which is about 20 or 30 years evolving, technology transfer. Technology transfer is the process of taking an invention from its inception in the lab to a commercialized product. The problem is we in academia don't like to think about commercial values. We like to teach and to fulfill our inquiry about problems and explain to people things. So the obstacles to effective technology transfer is that in the traditional view, the overt commercialization is in contradiction to the pure goal of scientific inquiry. So this is what puts a lot of restraints on universities to completely transfer to a commercial entity. So universities now try to find a middle way between producing IP, protecting it, marketing it, and the traditional learning of any scientific problems, teaching and learning. So I summarized all the stages of technology transfer, which we'll not be talking about all of those in our talk, but this is all of the stages from start to the finish. We usually used to get support for our research, even in a traditional way, from government funding, endowment, corporate funding, and personal or anything else. In our structure here in KAU, now we usually get our funding mostly from the government. Endowment is becoming an increasingly important branch of funding. Now the university has special administration for the endowment. Corporate funding we are lagging behind very much, and personal funding is also becoming more important nowadays. So from research, inventions get disclosed to the university, and here we disclose it to the patent units in DSR. We get the patent, which will hopefully get transferred to new products to promote higher standards of living. This will go to the economic growth, will create new jobs, and from the patent we can get licensing instead of producing the product, but selling the patent itself, and the revenue will go back to the cycle. Okay? Not all stages are now well developed in the university. We in this we are taking a very starting steps in the university. So we are establishing offices to take care of our producing products, commercializing those, starting the economic cycle of the products. So these are only in the beginning stages. Licensing also is in the beginning stages, but I would say the patenting also is in the starting stages in the university and is not well developed. But now we are getting good results, and this process has been accelerating through maybe 5 years ago. To give you an indication of the importance of IP for the universities and for the economy of any country as a whole, now statistics shows us that 38% of the US GDP, which is about $20 trillion, is connected to IP. So this is a huge amount, a huge chunk of the economy of the US. 80% of the market value of publicly traded companies in the US comes directly from IP. Okay? And a high percentage of intellectual property which is produced in the United States directly comes from the universities. So there is a very strong link between the universities, higher education, intellectual property, economy as a whole, and companies in the market. Now we go to the main theme of the talk, which is IP, intellectual property, and we will only concentrate on patents, which is one of the three parts of IP. Copyrights, as I wrote here, includes sculptures, graphics, music, radio, audio, video, computer software, codes, and books, and anything else will go under the copyrights. Trademarks, like slogans, sounds and colors, logos, etc., are parts of intellectual property, but in science and engineering and medicine, the most important part is patents. So we will concentrate on patents and its importance to KAU and the country as a whole. What is a patent? A patent, by definition, is a right to exclude others from performing certain activity in the country of issuance. So two important things to consider. Exclude others, which means you are creating a monopoly of your idea. This is the first one. The second thing is country of issuance, which means if you want to protect your idea or your invention in the whole world, you have to apply for patent protection in each and every country in the world. And that's what the companies do. If the company who produced this has a protection of it, it will have a protection in 150 or 200 countries all over the world. Okay? So if you protect your invention in Saudi Arabia, a company in China will produce it and sell it with no hesitation if you don't have protection in China. For a university, which is not a commercial body, and is not a company, does not have a lot of financial resources, so it will protect the patent in one country unless it has the infrastructure of commercialization, which we talked about in the stages. So there is a company will market the product, and it will see the prospects of generating money from the products. It will take the decision to protect it in many countries. So decisions are made like this. But for the university's sake, to show that we are producing inventions and we have something that will maybe generate some money, we need to show that we have some patents. So this is a starting point. So no company will talk to us if we don't show them our portfolio of patents. So this is the first step a university should have in starting the process.
So university can protect a patent only in the country of where it is, but not outside?
Now it's a matter of your choosing. You can protect it anywhere. You can protect a patent in Saudi Arabia, in the GCC, in the United States, in Britain, but it will cost you money.
Yeah.
So if you have money and you want to protect it, then you go ahead. But only the protection will not generate you revenue. You should have whole stages from producing the idea, producing the product, commercializing it, and then you have to protect it everywhere. But if not, then you have to show that you have ideas. You might end up selling that idea before it gets protected. So I will explain that in the stages of the protection. Usually protection of the invention is for a limited period, generally 20 years. After that it will become a public knowledge.
You haven't reapplied?
Excuse me?
You can't reapply?
No, after 20 years you see it in drugs. So a company will produce Lipitor, it will have a monopoly on it for 20 years. After that, any generic company can produce that.
20 years is more than enough to get some kind of...
So they will introduce a small change on the product and get 20 more years. Okay, what can be patented? The inventions must be novel, useful, and non-obvious. I don't want to go to explain this. It cannot be an idea, only the idea, but you have to connect the idea to a tangible product or a product that can be produced. You don't have to produce it physically, but you have to prove that a tangible product can be produced from this idea.
But the patent itself is intangible. I mean, it does not have to be tangible.
No. You don't have to actually to produce the invention. This comes to in the next stage. If you have to prove that this product works, then you go and produce a prototype. But for a patent, you don't have to produce the prototype. It cannot be a law of nature. Mathematics law cannot be protected. Scientific principles also cannot be protected as a patent. So why we go and protect or have a patent issued for us? And some of the point I'll speak of is relevant to our university. Some are universal. So it's a source of recognition of the inventor. This is obvious. We need to publish papers and put our names. It's the same in the patents. Competitive advantage. It is important for companies and people who produce things and sell them. Protection against imitators. This is important also for someone who wants to sell his invention. Royalties. So if I sell my patent before I produce the products, I can get royalties from selling the patent. And this is for KAU staff with special provisions in this, okay? So you can get an increase in salary if you have a patent.
Now, after this, nobody will publish papers.
Yes. Yeah, it's important.
But it's
So,
important.
yeah.
Even when you publish papers in ISI, you get also increase in salary, right?
Yeah, but not
About 40%.
But here you have to wait 3 years, then you can wait 1 year.
Okay.
Excuse me, please. Can you go back to the slide before that? Why patent? I think very important why patent is just to keep the minds working and innovation, because if we don't have patents, people will stop innovating because they will not have rewards. I mean, they can't. The innovation rewards will not be there for them.
Yeah, it could be.
I think that's important.
Keep in mind that companies usually don't advertise their inventions from the start. They keep them secret as long as they can. Then they will patent them. They will try to extend the 20 years. So they will milk the products 100 years if they can. Yeah. So a lot of companies don't advertise their inventions. Even if they don't need to protect them and produce the products in a closed box and sell it to you, it's better for them, money-wise.
But if they don't protect them, they can't.
Dr. Ajur, I
Yes.
think we did Dr.
Because this is very important.
Yeah, but we can ask towards the end.
I know, but this is very important.
We will stick
Because
at this.
if the company doesn't protect the product and they don't paint it, they can't stop somebody else from doing it.
I think Dr.
Yeah, yes, they can.
Yes, they can.
How?
They can put the provision, for instance, you are not allowed to work for their competitors.
Sorry?
For instance, they can put the provision in a contract, you are not allowed to work for their competitors.
Yeah, but if somebody else.
Dr. Ajur, let me stop it here. I think we let Dr. Muhammad finish and then we can go.
I will open for action and comments. Okay, types of patents. I'll go through this quickly. Design, appearance, utility, function, inventions, provisional patents, non-provisional patents, international patents. Some of those I spoke about. The most common type of patent important for scientists, engineers, are the utility functional inventions. So any instrument you have, any chemical you produce, any drug you produce, it falls into this category. Provisional and non-provisional I will speak about later, and international I spoke about earlier, that you have to protect your invention if you need to in each and every country in the world if you want to sell the product. So what are the steps of getting, and this is in a university setting, you get your invention or idea protected from your lab. You have the invention, patenting with the patent units, DSR. So after you finish your lab work, you get in contact with our office, and before starting to publish, it's important. So you think in parallel ways. If you want to publish, first speak with us. So we will hold you about 6 months or a year. Will not allow you to publish your work until we file for protection. Then you can go ahead and publish. Okay, if you want to protect or get a patent. Okay, but if you published your work, then it's a matter of time. The law in the United States says you have a 1 year period. They call it a grace period for applying for a patent. The first day after 1 year, you cannot apply for it. It's public knowledge. But now, if somebody else beat you to the application at the United States Patent Office before the year ends, he might get the invention and not you. So that's why I'm saying it's important to speak to a patent unit before you go ahead and publish the patent.
We can apply, for example, 3 months before the publication?
Yes, yes. The important thing is because it depends on individual cases. So first speak with the people in the unit, then they might tell you go ahead and publish. Okay, commercialization, as I said, needs a tech transfer office. This is an official term in most of the universities, technology transfer office. We have a startup technology transfer office here at the university. Usually, the work of patenting and commercialization is under one roof, which is the technology transfer office. Our setup is a bit different. We in the patent units take care of protection, and the technology transfer office people supposed to take care of commercialization. So, but they are now in very starting stages of their office. So how it works? Approach the Deanship of Scientific Research, which means my unit. If you have a research and you don't know if it's patentable or not. So I can answer your question. I can say to you, no, it's not patentable. You can go ahead and publish the paper. Or I will say this is patentable work, and we can go ahead and start the process of protection. Fill in the application and contact forms, patentability search. After the first meeting, we can start requesting a patentability search report from our attorney office, which we deal with. It will cost about $750, and it will take about 4 or 6 weeks. They will produce a report with their opinion. So it's an independent opinion, not from our side, not from you. And they will say, okay, we agree, this, go ahead and protect it. They might give you a green light, yellow light, or red light. Okay? We can change their mind from red to yellow, or from yellow to green, or from red to green. So it's negotiable, okay? Depending on their understanding of the idea and your explanation of the objections. If a green light has been given, then we ask them to go ahead and draft the application. It will take about 6 weeks or 8 weeks. Then you will review the draft, After that, we go ahead and apply at the USPTO, which is now the standard method. We now apply at the USPTO. If you would like to apply at the Saudi office, you can go ahead, and it's easier to apply directly from yourself to the office instead from our unit to the Saudi office. Okay? It's a lot easier. So that's why we don't go and take your file and submit it to the Saudi office. It will be very difficult. After application, so the date of filing is 1st of January, for example. 18 months later, the USPTO will publish the application. Okay? After 18 months, it might take about 4-6 months for an examiner to look at your file in the USPTO. It will give you, they call it an office action, like a review of the application. It might have objections to the claims, or it might allow it. They call it allowance, which means that they will issue a patent for the invention. Usually, there is an objection. 95% of time, the examiner will object to the claims and reject them. Okay? So we have to go forward, backward, and discuss with him things, maybe 1 time, 2, 3, 4 times, okay, to convince him that our idea is different than what he says, references he brought. Okay? The whole process might take 2 to 6 years. Okay, from the start, once you speak with me, until you get your patent, it might take 2 years, 3, 4, 5, 6. Okay? That's why people in academia say, no, we don't want to deal with this.
It's a third.
Yes.
I can publish everything in
Yes.
3 months.
Yes. Yes. In industry, it doesn't work like this. So they have the invention. They go and protect the idea with a provisional application. A provisional application means that this is my idea, this is what I have. The USPTO will take the file, put it on the shelf. Anybody who comes with an idea similar to yours, they say, no, this idea has been taken. But they will not examine the file. Okay? So you have 1 year, the company will explore the market, produce a prototype, and see these products will produce 100 million, or it will produce 2 million. In that 1 year, they will decide if they want to go ahead and protect the invention. So they will change the application from a provisional application to non-provisional application to get the certificate. Okay? So companies like the 6 years. They don't like 1 year. They want a 6-year period. Okay? So they will apply a provisional application. They can extend it with tricks. So change the invention a little bit and add more data and make a new provisional application, and then study the market.
So then in academia, during those 6 years, is anyone allowed to, let's say, work on that idea that I have, or are they excluded during the 6 years of this process in academia? So
No, if you file today at the USPTO, now your invention goes in the database. So any new invention similar to yours will get excluded.
Even though this, even still,
Yes, even though you didn't get the certificate,
okay.
because it's your idea and it's under examination. So 6 years is a long period, but we had patents issued in 18 months. We had patents issued in 2 years, 2.5, 3, you never know.
So then, for instance, if I am in academia, and I come from academia, and I start my process now, when can I go to industry? From university. For instance, I call you, you say yes, it's patented, let's launch it at the Uspto. At what time can we go to the industry to commercialize it?
The ideal situation is,
Maybe Dr. Muhammad, we can leave the questions towards the end.
we can come to this later, okay? Okay, important notes about how we work in the DSR. All patents through DSR will be assigned to King Abdulaziz University. This is a second turn-off, along with the time. So people think, this is my idea, why the university is the owner of the invention. But this is the standard practice all over the world. You work in the university, you use our labs, you get your salary from the university, then anything you produce should be attributed to the university. We didn't have that culture in here. Everything is ours. Okay? Now people are starting to accept this. This doesn't mean that if you generate money from the invention, it's universities. No. The university will give you a big chunk of the money. In here, our rules state that 70% of the proceeds go to the inventor. In the United States, 15% or less go to the inventor. So our setup is to encourage people a lot more. All applications so far are non-provisional utility patent application. So we go through the non-provisional path to obtain the certificate. Okay? This is to build up our portfolio of patents. I imagine in the future we'll go the other way. So we limit applications and maximize prospects of producing, generating revenue. Average cost of protecting an invention is about $14,000. The university bears that cost. Okay? So if you come to me with an invention, I might ask you for the $750 returnable upon issuance. Okay? But the 14,000, it might be 10, 12, 14 or 18, we will pay it. Okay, this is just to show you how patents looks like. There is a cover sheet with the formal cover sheet, and you see here assignee is King Abdulaziz University, and the inventors also are listed. Okay, so assignment to the invention doesn't mean your name has gone from the invention. Your name will be in the invention, but the assignment also will be indicated. A history of the application times. So we filed this one August 24th, 2009. It got issued November 8th, 2011. So this is one of the fastest ones we got. Okay. So fast and slow depends on the specialization. So if it is a dental patent and the examiner has 20 files to examine, okay, and then an electrical engineer, the examiner has 200 files to examine. So he will take one by one. This one will finish the 20 in 2 months, and the next one will finish his in maybe a year or so. So this is why it takes a long time for examination. And then there are the abstract of the patents, and summary of the invention, field description of the patents, and claims. So in the official writing of the patent, there is claims. Attorneys who are trained to write claims. The writing of a patent is a bit different than a research paper, because we have to write in a special way to protect the more general aspects of the invention as we can. So nobody else can come up with any idea close to our idea. And this is an art they are trained to do, but you can write it yourself. Then your writing will be maybe poor, and the protection you get will be not too exclusive. Okay? That's why we hire attorneys, and that's why they will take a lot of our money. Now, from our unit, we started, established our unit in 2009, and we now have about 50 issued patents from the Uspto, and we have about individual researchers has maybe 15 or 20 patents issued from the Saudi office. We have about 100 applications in process through our unit. Majority of applications come from science, especially chemistry and physics, engineering, medicine, dental or general medicine. I think this is my last slide, and we can open the door for questions.
Yeah, okay. Well, we give first the first thing to ladies, the female section. Any questions from the female section?
I have a question here. Hello?
Okay, go ahead.
Okay. You're mentioning the average cost only for filing, right? For 14,000. What about the maintenance cost after that? How is it going to be managed?
Okay. We also pay for the maintenance cost. Maintenance in the United States, you have to pay during the 20-year protection period 3 times. So I think the first one starts in the 3rd year after the issuance. The second will be at the 7th, and I think the 3rd payment will be at 12th or 13th year. So we are now in first period of payment of the maintenance fee. So you have to decide if you want to continue to protect this patent or no. So if you don't have a product, then from a business standpoint, what's the point in protecting the patent?
And by the way, okay, so basically the way we understand is that if the patent has a commercial value, then you should continue protecting that.
Yes.
Now, how much is that money, just to get a feeling?
The first payment is $1,300, I think.
And the second, is it the same amount?
I think it will increase.
Okay.
Yeah. In Saudi Arabia, you have to pay yearly. For individuals, 500 riyals, and for companies and institutions, it's 1,000, doubles every year.
Any questions also from the female section? Any more questions?
Another question, is the cost, all the costs will be bear by the university, or how can we start with? Do we have to know the university have the budget for patent, or we just can submit the application?
No, you can submit directly. Now we pay all the costs. So anybody in the university has an invention and he wants to apply for a patent protection, we can bear the cost. I think in the future it might start get limited. So if a lot of applications came, then we have to start selecting the best.
Any more questions? The middle section?
Thank you very much.
Okay,
for the
thank you.
presentation.
Thank you.
Thank you.
Okay, now usually students will ask students. Any questions from students? Please. Okay. Maybe you can use the mic if you don't mind. It'd be a good idea. This will be recorded for you.
Assalamu alaikum. I have a question. The patent belongs to the King Abdulaziz University, but I'm an inventor. As an inventor, do I also say how the patent will be used? For instance, to which industry we're going to sell it, under which conditions we're going to license the industry. Do I have any saying in that, or that's King Abdulaziz University?
You have to differentiate between the protection process and commercialization process. So there's two different. Usually, if you know that your product is going to be sold, then you have to start thinking about that before you get the certificate. So you have to talk to the people who take care of this, and you should have the say on how to proceed, because you are the one who knows the most about your invention.
Okay.
But I say that our commercialization office is in its starting stages.
Still.
Yeah.
Okay, so Dr. Hatem, you have a question?
Thank you. Among the 50 issued patents, are there some patents which are commercialized also?
They are no.
No?
The straight answer is no. But the office, the TTO office, I think they are exploring commercializing some of those. I don't know if they got some fruit or not. I don't know.
Okay, thank you.
Okay, assalamu alaikum. Thank you very much indeed, Doctor. Precise and concise, very good. My question is about the evaluation of the patent. When somebody applies for a patent, how do you decide whether this really deserves to be patent or not? How? On what basis?
Okay. Now, there is a difference between business standpoint, academia standpoint. Okay? So the business people will say, will this generate money for us or not? This is their basic criteria of patenting or not. From scientific point of view, any idea which is new, applicable, can be patented. Okay? So
you don't reject them?
no, we don't reject anything. Now, at this time, universities, a lot of universities, the US, the UK, everywhere, they won't reject any patent protection from their staff. But a lot of US universities, after they establish the technology transfer office, they will select. So they have 100 inventions produced from the university. Which ones will have likelihood of generating revenue? They will protect those first.
Just one more thing. Is it likely that we will have in the near future an international office where once you apply to it, you are protected all over the world?
There is already. I didn't mention that in here.
That's what
Now, the international law, there is a patent cooperation treaty,
Yes.
which is abbreviated in the BCT treaty, and Saudi Arabia is a part of that treaty. If you apply for a protection, say in Saudi Arabia. Okay, you can use that file to protect through the organization, which is called the WIPO, and it's headquartered in Geneva, to protect your invention in as many countries you want. Yes.
Okay, any more other questions?
I just maybe not a question, but a request, if I may humbly, from your office, because from what I understand, the patent it's very appealing. However, patent itself doesn't mean a lot. Commercialization is very important.
Yes.
So I was wondering if maybe in future from your office we can expect the same talk on commercialization of the ideas. If I don't know if that's the same office as yours, just like you had now about patents, how the commercialization is done, and what we can expect from them. Could that be also arranged?
Yeah, I think so. If he chooses so. The office is run by Dr. Muhammad Arif, and can arrange with him.
Yes, yeah. Okay. Oh, so you keep, I'm losing weight this way. Yeah, you have a mic there? Or no. Okay. Yeah. Okay, good.
Thank you very much for a very nice presentation today, very interesting. I have a question that once we were trying to patent one of our idea, and it took about 6 months for us to search here and there that whether somebody else has done this work before or not. So we saw there was nothing, and the day we were filing our patent, by somehow we saw a similar work in a European patent. So how do you make sure that this thing not happens to some other patents?
Okay, the $750 I talked about, it pays for a search report, and we send the file to that office, and they will search in all databases of issued patents and research databases through Thomson Reuters. Even in other languages like Chinese and Korean and Japanese, they will search all of that, and they will give us a report of all similar issued patents and papers, and they will make their decision on that. So you should do your own research, but then we will do another one, comprehensive one, and we will make decision based on that.
Okay, thank you. Thank you very much.
Any more questions? Please use the mic, please. Please record it.
Assalamu alaikum. My question about, is there any, a bit strange, but I would like to ask, is there any kind of stalling idea during the process happened in the past, or 100% guarantee no one will catch something, or
maybe
I'm not sure
if I understand your question. You're saying is that the ID or the whatever, is it like 100% new?
No.
Yeah, okay, this is
No,
already
no.
20. How much there is an overlap between an all ID?
Okay. The easiest way to get a patent, so look at the existing system, make an improvement on it. Okay? So if you made a 10%, 15% improvement on an existing system, you can get a protection. So, and this is the fastest way and easiest way. So it need not to be 100% new system or new idea. Is this your question?
and also is it 100% guarantee the process will be secret? That means no one will steal my
Okay.
or my dog will
Okay, this is A lot of people have this concern. 100% guarantee? No. Anybody can look at your file and then if he wants to steal it, he will. But we have protection by law. So if our files went to the attorney, then he is obliged to not disclose things.
NDA, there is non-disclosure agreement.
Yes. So, but even people breach the NDA. So it happens.
Doctor, can we patent the same idea for two different applications?
Yes.
The same invention, two applications?
No, same
Huh.
idea, but two different applications. One, for example, in medicine, the other in chemistry.
I think from my experience, you want to write the claims as broad as you can. Even if not, you know that this system can be applied to ABC. You anticipate D and E. You don't know what they are, but if you can put it in anticipation in the claims, it would be better.
Please, what stands for USPTO, please?
United States Trade and Patent Office.
Is it based on USA?
Yes. It's the office.
States patent.
I forgot to say this. Only governments can grant a patent. Okay? Only. So, if you want a protection in Saudi Arabia, then the Saudi government will grant you a patent. If you want a protection in the US, then the USPTO, which is a government body, will grant the patent. And there is an office in each country around the world. So, the university cannot grant a patent because they don't have a power to enforce the law. So, only governments can, yeah.
I think we maybe we can have another dialogue, you see, because it's running, and also have some questions. I have to leave some time for myself. Okay. Okay. I actually have a few questions actually. One question is that a lot of us working on algorithms, and I know that you can patent algorithm. Maybe you can say some words on this.
By algorithm, you mean code?
Not necessarily a code, but it's a certain procedure to do something.
Okay.
Not necessarily a software, but it is a certain process to design maybe a filter, to design something, to or a new technique to improve the whatever.
Okay, if I can use the software analogy, it might give some answer to this. A software itself cannot be patented,
Yes.
the code. But if you combine the code with a system that do a certain function.
Yeah, let me give you an example.
Yeah.
For example, for example, let me say an adaptive filter, a new structure, a new
Yes,
system or something, which is,
Yeah.
is mathematical in nature, of course.
Yes.
But
But there is an application to that.
Yeah,
So-
there's
so
an application. You
it's
can use it in
patentable.
telephony, you can use
Yes,
it in
yes.
whatever. So this
It's patentable.
can
Yes,
be
yes,
patented.
yes, yes.
Okay. Now the other question I have is that looking at the huge cost, $14,000, actually it's a lot of money, and actually some of the patents are nonsense. Actually, some
Yes.
of them are nonsense.
Most of it.
And of course, the one that leads to, maybe you have the data, you know that you are talking about the amount that are not really commercialized, maybe 99%, is it? You have the numbers?
I think a number I have,
Or 90 or something?
no, 95% will not see the prototype.
Will not see the prototype.
Yes.
And you still pay the 14,000?
Not us, this is worldwide.
General worldwide.
That's worldwide.
Okay,
We
this is
are actually in a
worldwide.
good shape. Still,
So
absolutely.
everywhere, even in the United States, 95% of the patents will not see the prototype. I think less than 50% from the 5% will see the prototype. And 50% from that 50%
Yeah.
will go to commercialization.
So 1.25%.
So some of that will generate a lot of money.
And some will
Okay.
protect that, yeah.
Yeah.
The other question is that when you protect a patent, like for example, suppose you know there is a new like a nano center or something or solid state, and it is only patented in the US. Can I use it in Saudi Arabia without really buying the patent or having a license? I mean, how it works? Because you mentioned that the patent is only associated with the country.
Yes, the protection.
The US, Germany, or whatever.
Yes. The protection by law is enforced in the country of issuance. Okay? You can use it anywhere else, but somebody else can produce a product except in the United States.
Yeah, you know, for example, there is a patent in the US, for example.
Okay.
I've checked that it was not really, it's only patented in the US. And I took that ID and I said, okay, let me do it in Saudi Arabia. I want to
Okay, it is still stealing.
Sorry?
You stole his idea, isn't it?
Yeah, it is
okay.
stealing, but
it is still,
about law.
But they might file an injunction in the court, and you might get penalized.
So basically, then the point is if there is a patent there, this does not mean that anyone else in some other country can use it because he can get into trouble. Is this correct?
He might not.
He might not. He has to take a...
Yes.
No, but the other gentleman will say, this is my patent, it is protected in the US, but the other guy in Saudi Arabia said, well,
yes,
Saudi Arabia,
yes. So how can he decide if you file a suit in Saudi Arabia? He doesn't have the means.
Now the other question is the following. Suppose somebody, there is a good patent in the US, and somebody in Saudi Arabia said, well, let me do it the Alibaba way or whatever. I will take that patent and I will file it in Saudi Arabia. Will this work?
No.
Two different countries. I'm just, you know.
Ideally, no.
Ideally, no.
Because the search process in the Saudi office will search in the US.
So basically, the search is not done. This is the search is not done within the country.
No.
It is international.
International, yes.
Okay.
Yes.
Then my last question is the following: what is actually for us as a faculty and students as well? What is actually a sort of formula that we can go in the process, because we are more used to write research papers, but sometimes some of the work is not like a research paper, some of the pattern. So is there any like a template or some easy ways, easy steps for us so that we do a job, we do something that will make it easy for you to proceed with the application?
Okay, the easiest way I found, I will let people write a scientific paper, like they used to do. And I will give it to the attorney's office. He will transfer it into a legal document. Okay? So it's easy for you to write a research paper, and he knows how to do it. So we will not trouble you to write anything else besides the scientific paper.
Suppose somebody who has the ID, he made a prototype out of this invention.
Yes.
So what is does this change anything? Like he has an invention, he can make photos, he can.
No.
It's the devices here.
No. Prototype will not play any role in granting the patent.
Okay, I think you have a question, last question.
Yes, just because just to build on what Dr. Bay said. So for instance, someone issues a patent, the United States government issued the patent, but it is not patented in Japan. That means in Japan he can use that, without the approval from the US Patent Office. So if I go with King Abdulaziz University and I say I want to protect it in US, Russia, and Japan, can you also do that? And how is it handled then when it comes to the language?
The simple question is, we cannot do that.
You cannot issue patent resistance.
We can do that, but we won't do it because it will generate a lot of cost for nothing. You have to do a study first and to prove that you will get compensated for the cost you paid. So if there is none of this study, then why pay it?
Okay, I'd like to thank Professor Muhammad for this very interesting and very informative, and I hope from our department also when we spread the video to our colleagues, we will get more patents from our department.
So I know Dr. Hatem is applied with us. مين دكتور مين تاني؟ إيه دكتور
لا شو نزيه
نزيه عثماني. One issue also.
And maybe we should, I mean, the point is that, as you mentioned, for us, we feel there are a lot of things that we can patent, but we, you know,
Yes.
We don't want to go through this process. We should really overcome this difficulty, actually. Okay, thank you very much again, and thank you.